Imagine waking up this morning right here in the United States, grabbing your phone before you even get out of bed, and realizing that the immigration rules directly affecting your green card application, your work permit, your ability to travel, and your entire future in this country have shifted again overnight. Surprised, and the people around you, your coworkers, your neighbors, your family members sitting at the same dinner table, have absolutely no idea it happened. If you are currently living in the United States with a pending I-485 adjustment of status application, if you hold temporary protected status, if you are sponsoring a family member from abroad, or if you came here from any of the 39 countries currently under a presidential visa restriction, what we are covering right now today directly affects your life inside this country. Rushed, do not go anywhere. Welcome back to US Visa and Green Card Info, the channel built specifically for immigrants and green card seekers living right here in the United States who need verified, accurate, and up-to-date immigration information without the rumors and without the panic. If this is your first time watching us, hit that subscribe button right now and turn on your notification bell, because in 2026 immigration policy inside the United States is moving faster than at any other point in recent history, and missing a single update could cost you months or even years of progress on your case. Let us start with the single most important policy development that is reshaping the immigration experience for people living right here inside the United States in 2026. Presidential Proclamation 10998 took effect on January 1st, 2026, and it remains fully active and fully enforceable today. This proclamation restricts, and in many cases completely suspends, both immigrant and non-immigrant visa issuance and entry for nationals of 39 countries. The list includes Afghanistan, Iran, Syria, Yemen, Somalia, Libya, and dozens of additional nations. Now here is why this matters specifically for people already living and working in the United States. If you were born in any of the 39 affected countries, and you are currently going through adjustment of status right here in the US, your case is now subject to heightened national security scrutiny that was not part of the process before January 2026. If you have family members back home in any of these countries who you are actively sponsoring for immigrant visas, their ability to receive that visa and travel to join you here in the United States has been severely impacted regardless of how long your petition has been pending. If you need to travel internationally and re-enter the United States, you need to consult with a licensed immigration attorney before you book any flight, because re-entry risks for nationals of affected countries have increased dramatically under this proclamation. Limited exceptions do exist, including certain diplomatic situations and individual waivers, but those exceptions are narrow and difficult to qualify for. Do not assume you qualify without professional legal guidance. Now let us get into the March 2026 Visa Bulletin, because if you are one of the hundreds of thousands of people living in the United States right now waiting for your green card priority date to become current, this month's bulletin has information you need to act on immediately. The March 2026 Visa Bulletin was officially released in late February 2026, and it is the most current monthly snapshot of where immigrant visa availability stands right now. And here is the first thing every adjustment of status applicant living in the United States needs to know about this month specifically. USCIS has officially confirmed that for March 2026, they are accepting I-485 adjustment of status filings based on the dates for filing chart rather than the final action dates chart across all family-sponsored and employment-based categories. If you do not fully understand why this distinction matters, let us break it down clearly right now, because it could mean the difference between you being able to file today or having to wait potentially another year or longer. The final action dates chart shows the date at which your visa is actually ready to be issued and your case can be fully approved. The dates for filing chart shows an earlier date that allows you to submit your I-485 application and begin collecting important benefits before your visa is fully available. When USCIS uses the dates for filing chart as they are doing right now in March 2026, eligible applicants living in the United States can file their I-485 earlier than the final action date would normally allow. And filing your I-485 even before your final approval date arrives unlocks 3 critical benefits for you right here in the United States. First, you can apply for your employment authorization document, your work permit, allowing you to work legally and not depend solely on your current visa status for employment authorization. Second, You can apply for advance parole, which is a travel document that in most cases allows you to leave and re-enter the United States without abandoning your pending adjustment of status application. Third, your case gets into the official USCIS processing queue earlier, which can reduce your overall total wait time for final green card approval. If you have been sitting and waiting and watching your priority date month after month, right now is the time to pull up the official dates for filing chart on travel.state.gov and check whether March 2026 opens a filing window for your specific category and your specific country of birth. Let us now walk through the employment-based category movements in the March 2026 Visa Bulletin one by one, starting with the most significant development. The EB-2 category, which covers professionals with advanced degrees and individuals with exceptional ability, saw a forward advancement of approximately 11 months for India and certain subcategories within the dates for filing chart. For Indian nationals living and working in the United States on H-1B visas or other employment-based statuses who have been waiting in the EB-2 backlog, this is genuinely meaningful forward movement. Even an 11-month advancement in the EB-2 India category matters when you are dealing with a backlog that has historically stretched across decades for Indian-born applicants. Check your priority date on your I-140 approval notice right now and compare it against the current EB-2 India dates on both charts. For most rest of world countries, meaning countries other than China and India in certain subcategories, EB-2 has returned to current status in March 2026. If you were born outside of India and China and you fall into the EB-2 category and you are living in the United States right now, current status means there is no priority date wait, and you may be eligible to file your I-485 immediately if all other requirements are met. Do not delay. The EB-4 category covering special immigrants, including religious workers, saw strong and consistent forward movement across multiple subcategories in the March Bulletin. If you are a religious worker living in the United States under an R-1 non-immigrant visa and you are in the process of transitioning to permanent residence through the EB-4 category, this month brings positive movement for your timeline. Verify your specific priority date against the current charts directly on the official Visa Bulletin page. In the EB-5 immigrant investor category, China saw a forward advancement till October 1st, 2016 in the unreserved category. For Chinese nationals who are currently living in the United States as conditional permanent residents or who are waiting for their EB-5-based green card to fully process. Any forward movement in this category represents real progress on one of the most backlogged investor visa queues in the entire system. Now let us talk about the family-sponsored preference categories, because for many of you living in the United States right now, these categories represent your ability to bring your spouse, your children, your parents, or your siblings to join you permanently in this country. The F1 category, covering unmarried sons and daughters of U.S. citizens, showed limited movement in most regions for March 2026. The F2A category, which is particularly important because it covers the spouses and minor children of lawful permanent residents, meaning green card holders, saw a slight forward advancement on a worldwide basis this month. If you are a green card holder living in the United States and your spouse or minor children are still waiting abroad, this forward movement in F2A, even if modest, brings them marginally closer to being able to join you here. The F2B category, covering unmarried sons and daughters aged 21 and over of permanent residents, showed minimal movement this month. The F3 category, covering married sons and daughters of U.S. citizens, saw some positive advancement specifically for Philippine-born applicants. The F4 category, covering brothers and sisters of adult U.S. citizens, remained largely unchanged across most countries for March 2026. For every family-sponsored category, pull your exact priority date from your official USCIS approval notice and compare it against both the final action dates chart and the dates for filing chart on the current official Visa Bulletin before drawing any conclusions about your filing eligibility. Now we need to address something that is directly and painfully impacting people living right here in the United States who have family members currently stuck in the consular processing pipeline abroad. The Department of State has confirmed an ongoing and significant slowdown in immigrant visa issuance rates at U.S. embassies and consulates around the world. If you are a U.S. citizen or green card holder living in the United States who has been petitioning for a family member abroad, this slowdown is the reason your family member may have attended their consular interview successfully and still has not received their visa. This slowdown is being driven by two converging factors. The first is Presidential Proclamation 10998, which we already covered. The second is a separate administrative pause on immigrant visa processing announced earlier in 2026 that affects applicants from approximately 75 countries who may be evaluated under the current administration's expanded public charge framework. In practical terms, this means that even after a successful immigrant visa interview abroad, the actual physical issuance of the visa may be delayed indefinitely pending additional national security review. If your family member is in this situation, document every step of their process, maintain regular contact with the National Visa Center through official channels, and work with a qualified immigration attorney here in the United States to understand what advocacy options are available to you. Now let us cover 3 additional immigration developments from the past several weeks that directly affect people living inside the United States right now. The first is the formal termination of temporary protected status for Yemen. A Federal Register notice announcing this termination was officially published in early March 2026, and the termination takes full legal effect after a 60-day wind-down period from the date of that publication. If you are a Yemeni national currently living in the United States under TPS protection, you are running out of time to act. The termination of your TPS status does not just affect your work authorization. It affects your entire legal presence in the United States. You need to sit down with a licensed immigration attorney right now, today, not next week, to assess whether you have any alternative pathways to maintaining lawful status in this country, whether there are pending legal challenges to this termination that might provide you with temporary relief before the effective date arrives, and what your realistic options are before the 60-day window closes. Every day you wait makes your available options narrower. The second development affects employers and workers connected to the H-2B Temporary Non-Immigrant Visa Program. The H-2B cap for the first allocation of returning workers in fiscal year 2026 was officially reached and announced in February 2026. If you are currently in the United States on an H-2B visa, your authorized status remains valid through your current approval period. However, if your employer was planning to extend your H-2B status or bring in additional H-2B workers, that pathway is currently unavailable for this allocation cycle. Employers will need to monitor official USCIS announcements regarding any potential supplemental H-2B visa allocations for fiscal year 2026. The third development is one that affects virtually every single person who has a pending immigration application of any kind right now in the United States. A USCIS policy memo issued in January 2026 formalized significantly heightened review standards for employment-based I-485 adjustment of status applications and for certain benefit applications filed by nationals of countries designated as elevated risk under the current administration's national security framework. In plain language, this means that if you have a pending I-485 or any other benefit application sitting at USCIS right now, you should expect longer processing times than the published estimates suggest. You should expect a higher likelihood of receiving a request for evidence asking you to submit additional documentation to support your case. And you should expect more intensive background checks and security screenings that may add weeks or months to your overall processing timeline. If you do receive a request for evidence on any pending application, respond completely, respond before the deadline, and respond with the direct assistance of a qualified immigration attorney. An incomplete or inadequately supported RFE response is one of the most common and most preventable causes of immigration case denials in the current environment. There is one more piece of critical context that every person living in the United States and navigating the immigration system in 2026 needs to fully understand. The March 2026 Visa Bulletin contains a worldwide travel caution that directly references ongoing geopolitical tensions, including U.S. operations affecting Iran. These geopolitical developments are actively contributing to several real-world effects that touch people living right here in the United States. Processing timelines at USCIS are being affected by the increased volume of enhanced security screenings being conducted on pending applications. Biometrics appointments and interview schedules at USCIS field offices are experiencing delays in multiple regions of the country, and the digital vetting process for immigration applicants has been significantly expanded to now include comprehensive social media screening as a standard part of the adjudication process. If you are currently in any stage of the immigration process in the United States, be fully aware that your publicly accessible social media accounts, your posts, your follows, your group memberships, your online activity, and your digital history are now being reviewed as part of your immigration application. Anything that could be interpreted as contrary to U.S. national security interests may be flagged during this review process and used as grounds for additional scrutiny or denial of your application. Here are the official government resources that every person living in the United States and navigating the immigration system right now needs to have saved and bookmarked. For the March 2026 Visa Bulletin with the complete dates for filing and final action dates charts for every category and every country, go directly to travel.state.gov and navigate to the Visa Bulletin section. For official USCIS processing time updates, policy announcements, and newsroom releases that affect your pending applications inside the United States, visit uscis.gov and go to the newsroom section. For Department of State updates on embassy operations, visa processing changes, and consular announcements that may affect your family members abroad, visit travel.state.gov and navigate to the Visa News section. Do not rely on social media posts, informal community groups, or unofficial websites for information that could directly determine the outcome of your immigration case. Always verify with official government sources. Always consult with a licensed immigration attorney before making any major decision about your case. Living in the United States as an immigrant in March 2026 means navigating one of the most complex and rapidly shifting immigration environments this country has ever seen. Presidential Proclamation 10998 affecting 39 countries. The dates for filing chart opening filing windows for thousands of adjustment of status applicants. EB, to India advancing, TPS Yemen being terminated, the H-2B cap being exhausted, heightened scrutiny on pending applications, and expanded social media vetting are all happening at the same time right now while you are living your daily life here in the United States. That is an enormous amount to track and understand while you are also working, raising a family, and building your life in this country. And that is exactly why US Visa and Green Card Info exists. We are here so that you never have to figure this out alone. If this video gave you information you needed today, please hit the like button right now because it helps us reach more immigrants across the United States who urgently need these updates. Share this video with someone in your community who is currently in the immigration process because this information could change what they do next on their case. Subscribe to US Visa and Green Card Info and turn on that notification bell so every update we publish comes directly to you the moment it goes live. We will see you in the very next video.